Hello, I'm Georgina Jalbaud from LexisPSL Private Client, and I have here with me today Charlotte Edge, a barrister from Five Stone Buildings, who is recommended by Chambers and Partners for Court of Protection work, and Benjamin Blair, a lawyer from the official Solicitors Office, specialising in property and financial affairs Court of Protection work. And I'm just going to ask Charlotte and Benjamin a couple of questions on lasting powers of attorney. So what would you say, Benjamin, are the key advantages of lasting powers of attorney over deputyships?
Well, the first thing I would say is that with an attorney, the donor can choose who they want to be their own attorney. And this might be particularly important where the choice is not who you might ordinarily expect, for example, a close family member. With a deputyship, anyone can apply to be appointed as deputy, and the court has confirmed that there's an order of precedence that usually takes place in terms of who would be appointed. So it would ordinarily firstly be a spouse or a close family member, then it might be a close friend or the person's professional advisor, such as a solicitor or accountant, or finally the local authority or a panel deputy. So if you make a lasting power of attorney, obviously you can choose who you want to be your attorney.
Yes. Do you have anything to add to that, Charlotte?
Yeah, I mean, I think one of the points where it's really helpful if you've made your own decisions to who you want to be an attorney is perhaps where you've got people who are quite finely balanced, because that does leave the court with a very difficult decision. If you've got two children who fall out over which of them should be appointed your deputy, that can be a very expensive thing for the court to resolve. And actually it's perhaps not going to make very much difference to your life. It's just, you've just spent a lot of money, and in these sorts of cases it's generally P's money, on possibly just resolving a spat between your children. I suppose the other point actually that occurs to me is we're sort of thinking along the lines of property and affairs cases, but in health and welfare situations, the court very often prefers not to appoint a deputy. There's a principle in the Mental Capacity Act that a decision by the court, a one-off decision by the court, is always preferable to a decision or to the appointment of an attorney to make a decision. Now, in property and affairs cases, the court generally does appoint a deputy because there tends to be so much day-to-day ongoing management. In health and welfare matters, where there tends to be more, one decision, fairly big decision, but not that often, the court often says, well, a deputy isn't actually necessary, and those sorts of decisions should be taken collegiately amongst the family. If that's not what you want, and it is often not what people often want one person to be in control, you may only be able to achieve having a specific person in control if you make a power of attorney.
Yeah. Okay, thank you. And I also wanted to ask you whether, given the increased time and cost of putting in place a lasting power of attorney as compared with the old enduring powers of attorney, do you predict that more people will start losing capacity without a valid enduring or lasting power of attorney in place, resulting in an increase in deputy appointments?
I mean, I think the rationale for introducing lasting powers of attorney was the protection of vulnerable people, and it was felt that enduring powers of attorney were perhaps too simple and too easy to for abuse to take place. So it is now more difficult, I would say, to put in place a lasting power of attorney, but they are still popular. They are very popular, and I recently went to a talk given by the Public Guardian, who confirmed that there are several million lasting and enduring powers of attorney in place. I think one thing is that people are more aware of this area of law increasingly, particularly with press cases and the fact that Court of Protection cases are being reported. So I think they're probably going to be on the increase rather than the decline, I would say, lasting powers of attorney.
Yeah, would you agree with that?
Yes, I think I would. I think my experience since I've been doing Court of Protection work is that both the legal profession and the general public are much more aware of the types of application that can be made and the sort of things that can be done than they historically were. And I suppose one of the things that perhaps is a problem with the new lasting power of attorney form is I think everyone agrees it's a really horrible, awful form, and even very experienced and competent people filling it in make mistakes, and that certainly is now something that the court has had to grapple with, is the sort of problems that you get where the power hasn't been filled in correctly. That sort of thing, I think, it is causing some problems. I'm not really sure what can be done about that, because I'm not sure we'd want yet another form again, would we? But
I think the process is becoming easier with the advent of online LPAs.
Yeah.
You can now register online and go through the process of filling in the forms online. And I think that has simplified the process a bit. So hopefully that will help avoid errors at registration.
Yeah. Well, thank you very much, Benjamin Blair and Charlotte Edge.
You're welcome.